Thank you, Mr. Chairman. Thank you for holding this hearing. Over the last 8 years, I've been deeply disturbed by much of the conduct of the administration and its overreach of constitutional lines. Some of what has disturbed me and some of this overreach has taken place in the dark, in the categories of surveillance and interrogation, and some of this conduct has taken place very much in the open, as when the administration ignores the plain language of a statute, that when the Congress finds someone in contempt of the Congress, that matter shall be brought before the grand jury. Not may, not might, but shall. And some of the administration's conduct that disturbs me has been both in the open and in the dark, as in the intelligence leading up to the war in Iraq. I would like to use this opportunity to make an open call to this Congress to form a church committee to conduct an investigation into any of the encroachments upon the Constitution, any of the encroachments upon the legislative branch by the administration. It should be a bipartisan committee, as the church committee was. It should go back, I think, even before this administration and look at perhaps some of the roots of what has led to the abuses in this administration. I think that that inquiry should start now and should continue during the next session of Congress. What I would like to ask today are some of the steps that we might take immediately, in addition to initiating a church inquiry. I think, for example, it would be enormously important to require that when the executive takes the position that an act of Congress has overstepped Congress's constitutional bounds and intruded on the prerogatives of the executive, that it notify Congress of its intention not to comply. There is no guarantee, even with a signed statement, that Congress will find out in a timely way or ever that the administration has decided to act upon its statement and a signing statement. I think Congress should be notified whenever the administration takes an action or refrains from taking an action that's compelled by law under its own claim of constitutional authority. I would also like to get your opinion on something else which I think is deeply problematic, and that is the Office of Legal Counsel, and in particular the Office of Legal Counsel as it has related to the issue of torture. We seem to have a situation where the administration chose a lawyer to head the Office of Legal Counsel who was either a very bad lawyer or who was a competent lawyer but saw his job in a improper manner, saw his job as that of being an advocate of the administration and everything it wanted to do. We have had good and credible witnesses come before the committee to say that because of an opinion of that counsel, anyone who acted upon it, even if the conduct that was taken in reliance upon it crossed the line into torture, no one could be held accountable. Not the people who acted upon it, not the people who wrote the opinions, not the people who chose the lawyer to write the opinion. And I'd like to get your thoughts about how it's possible to determine accountability. Is there legal accountability? If there isn't, how do we instill legal accountability? Should we impose a requirement that on issues like this, that not long after the fact these opinions be disclosed to Congress, but that contemporaneously they be disclosed either to the Judiciary Committee or the Intelligence Committee or both? Would such a requirement interfere with the attorney-client nature of the opinions that come out of the OLC? And if you could direct some of your comments, I'd like to start with you, Mr. Schwarz. I appreciate a great deal of the work and recommendations the Brennan Center has made. And is that a possible way to provide some accountability?
The reliance on opinions is surely not a defense unless the reliance is reasonable. And I don't believe reliance on those opinions could have been reasonable. The second thought that occurred to me in listening to your remarks, which I thought were right on target, is there is already a law that says the President must notify the Congress if he decides that a portion of the law that's passed is not constitutional and that he's not going to enforce it. And one of President Bush's signing statements is, I'm not going to comply with the law that I should tell you that I'm not complying with the law. That somehow has the world totally upside down. All the opinions of the Office of Legal Counsel should be released. We're not a country where we can have laws and their opinions have some force of law. We're not a country where we can have laws that are secret. They should all be released. And Attorney General Mukasey was asked to do that by former Attorney General Katzenbach and I.
Mr. Schwarz, if I could just interject very quickly for a very specific follow-up for my time, which is, I think, already runs out even more. Does the Congress have jurisdiction to bring suit on a claim that the administration has not disclosed to Congress as it was required to do when it made a determination that it would not comply with the law based on its belief of its constitutional prerogative?
Yeah. I mean, that's sort of the issue that's raised in the suit you're now pressing in the district court in Washington about the refusal of Harriet Miers to appear and the refusal of Mr. Bolton to produce the documents. I think your counsel has put in an extremely powerful brief about the power of Congress to enforce those, but it hasn't been decided by the courts yet. If I could just add one other thing. On the subject of documents and things that could be done at the last minute, particularly if the Vice President's counsel is taking the position that the Vice President is not part of the executive branch, which, as Mr. FEIN pointed out, is a strange position in light of what they've previously argued. But you ought to go look at the Presidential Records Act and what's going to happen and make sure there aren't loopholes in that act that might facilitate people in the administration carrying away documents which ought to be part of the public domain.
Could I just answer, because I was in the Office of Legal Counsel for several years. This was during the Nixon impeachment. In fact, my first task was to examine after 100 years what was an impeachable offense. Nothing that ever produced was classified. They're all published. And the importance of openness is that shoddy scholarship is they change their mind. One of the things that happened, for instance, when the department for the first time tried to provide a public explanation for flouting FISA by conducting this terror surveillance program, their so-called white paper, after it was disclosed and shredded by many, after a year they went back and said, now we're going to get a FISA warrant in 2007. That was because it was so obvious that they had no legal argument. Sunshine is the best disinfectant, and that's why you would have a right to have access to every one of those opinions. Some of them might be classified, but you would have access to the legislative body because you're overseeing it. And I want to underscore what I think is a great forgetfulness of this branch. You have authority to oversee the exercise of every power, legislative, executive, and judicial. Oversight means checking, not asserting it by itself, but checking. That's what publicity and checking is about, Sunshine.
Thank you, Mr. Chairman.
Yes,